Hi, my name is Takith, and together with my groupmates, I will be talking about the law in Malaysia which relates to sexual offences against children. The entire presentation will be on explaining why the law in Malaysia is unsatisfactory when it comes to dealing with child grooming offences. In Malaysia, the relevant statutes governing the law on sexual offences against children would be the Sexual Offences Against Children Act 2017 or SOACA. Firstly, the relevant provisions that governs the offence of child grooming would be Section 2, Sub 1 of the SOACA 2017, which states that this act shall apply to a child who is under the age of 18 years, and where this act relates to any other written law, to a child of such age as specified in such written law. Next is Section 11 Sub 1 Part 3 of the SOACA is applicable when one is sexually communicating with a child, where Section 11 Sub 1 is subjected to Subsection 3, where any person who under Section 11 Sub 1A sexually communicates with a child, or under Section 11 Sub 1B encourages a child to sexually communicate by any means, commits an offence, and shall on conviction be punished with imprisonment for a term not exceeding 3 years. Section 11 Sub 2 Part 3 of the SOACA and Section 11 Sub 2 for the purposes of this section, a person is said to sexually communicate if under Section 11 Sub 2A, the communication or any part of the communication relates to an activity that is sexual in nature, or under Section 11 Sub 2B, any reasonable person would consider any part of the communication to be sexual. Under Section 11 Sub 3, no person shall be convicted of an offence under this section if the communication is for education, scientific, or medical purposes. For statutes governing the law on child grooming, it would be Part 3, Section 11 of the SOACA 2017, where under Section 12 Sub 1, it states that any person who communicates by any means with a child with the intention to commit or to facilitate the commission of any offence under Sections 5, 6, 7, 8, 14, or 15, or any offence specified in the schedule against the child, commits an offence and shall, on conviction, be punished with imprisonment for a term not exceeding 5 years, and shall also be liable to.
Hi, my name is Aaron, and I will be discussing the issues of whether child grooming laws in Malaysia are satisfactory. The aforementioned provisions about child grooming were enacted to punish those who commit such atrocious acts. These provisions are enacted under the criminal law system of Malaysia. However, in Malaysia, there are three types of legal systems: criminal, civil, and Sharia law. And Sharia law could be said to be contradictory to provisions on child grooming. The first issue is regarding the conviction of the perpetrator and the enforceability of the provisions laid out under the Sexual Offences Against Children Act 2017. Under Section 2 of the Age of Majority Act 1971, any person under the age of 18 is considered a minor. The Sexual Offences Against Children Act 2017 aims to protect persons under the age of 18 years as stipulated under Section 2 Sub 1 of the Act from any sexual offences. Child grooming is where an adult involves himself or herself in building trust and emotional connection with a child, and in an effort to gain access to time alone with him or her, which may lead to physical force, to sexually assault or abuse a child. The issue here is to determine what is the relevancy between child grooming and child marriage. Well, under Section 8 of the Islamic Law Enactment 1990, determines the minimum age for marriage, and it states that no marriage may be solemnized or registered under this, where either the man is under the age of 18 and where the woman is under the age of 16 years, except where the Sharia judge has granted his permission in writing in certain circumstances. In a news article by the Malay Mail, it stated that due to the dual legal systems of Sharia and civil law in Malaysia, it created various loopholes for adults to marry persons under 18 years. This was seen in a 2010 case where an 11-year-old girl was forced to marry a 41-year-old man by her father, who was a follower of a religious sect. And in another case, in 2012, the Kulim Syarat lower court granted permission for a 12-year-old girl to marry a man, and the child's father admitted that his daughter was raped by the man and thus agreed to the marriage. In another article written by Protect and Save the Children, a Malaysian child rights organization, states that a man should not escape criminal charges by choosing to marry his victim. To do so would not only be a contradiction to justice, but would ignore the emotional, physical pain and sexual abuse girls have to face in child marriage. And it creates a bad precedent that assaulting a child is fine, as long as the perpetrator marries her. Another factor regarding this is the Asian culture and perception towards child marriage. In Malaysia specifically, which its population is majorly Muslim, where it is a sin to engage in sexual activity without being married, and the concept of izzat, which translates to honor, and sharam, which translates to shame. These factors play a role in sexual abuse cases being underreported and the law not being enforced onto perpetrators and them not being convicted of their crimes. From the issues mentioned above, the question on hand is, what does these issues illustrate? In my opinion, yes, Malaysia have laws to punish such people. However, the issues here are firstly a predator establishing trust and emotional connection between a child and himself, and basically which may lead to them meeting up, and the perpetrator would be able to sexually abuse her, and a male predator is allowed to marry the victim to escape statutory rape and child grooming charges by Islamic law. This, in my opinion, is contradictory to the Sexual Offences Against Children Act 2017, which, in my opinion, the government should educate the population that child grooming and the abuse that occurs after should not be ignored, as if this act continues, it hinders a child's right to a healthy and dignified growth, which poses a threat to the economic and social development of a country. Therefore, reporting child abuse at an early stage can help stop the abuse and prevent further damage to the child and society in the future, and by reporting child abuse cases does not only help reduce the possibility of future crimes, but it also helps to put an end to the vicious cycle of child abuse. The second issue is that the tendencies for pedophilia could be said to occur due to some factors. As published by the Faculty of Islamic Civilization Studies, these factors would be such as the internet, the family environment of the perpetrator, and pedophilia is argued to be regarded as a form of mental illness. Under this issue, firstly, people now can easily have access to explicit content on the internet, and which may cause porn addiction and encourage such perversions towards children, as child pornography could be accessed through the dark web easily. Secondly, the most common factor associated with pedophilia is the individuals have experienced trauma from being the victim of abuse. Thus, children are in a circle of victims from predators and from victims of pedophiles to pedophiles. Therefore, in the context of Malaysia, children who have had a history of sexual abuse should be monitored and given assistance to avoid the formation of abnormal sexual perversions. Thirdly, pedophilia is regarded as a mental illness experienced by an individual who does not know that he or she is abnormal and has sexual perversions towards children. And pedophilia has been defined to be a mental illness by the 5th edition of Diagnostic Statistical Manual Mental Disorders in 2019. Although pedophilia is recognized as a mental disorder, pedophilia is usually punished without receiving any treatment. For researchers, punishment and treatment needs to be carried out simultaneously to make a significant impact on pedophiles. It appears that the law in Malaysia dealing with pedophilia would not be entirely adequate. It is adequate in a way that these criminals are punished. But we should ask ourselves, would such primitive ways of punishment, such as caning, be effective in deterring predators from reoffending? I think it would be more effective if a jail sentence is given, but at the same time, effort is made into rehabilitating and reforming the offender. Under English law, the relevant provisions on child grooming would firstly be Section 14 of the Sexual Offences Act 2003. It is on arranging or facilitating commission of a child sex offence and under Section 14, Sub 1, Para A and B, which states a person commits an offence if he intentionally arranges or facilitates something that he intends to do, intends another person to do, or believes that another person will do in any part of the world. And doing it will involve the commission of an offence under any of Sections 9 to 13. Section 9, which governs the law on sexual activity with a child. Section 10 governs the law on causing or inciting a child to engage in sexual activity. Section 11 is on the offence of engaging in sexual activity in the presence of a child. Section 12 is on causing a child to watch a sexual act. And finally, Section 13 governs the law on child sex offences committed by children or younger persons. Under Section 15 of the Sexual Offences Act 2003, it governs the law on meeting a child following sexual grooming. Here, Section 15 Sub 1 says that a person under 18 or over, which we will call A, commits an offence if under Para 1, A intentionally meets B, the victim, Para 2, A travels with the intention of meeting B in any part of the world or arranges to meet B in any part of the world, or under Para 3, B travels with the intention of meeting A in any part of the world. Furthermore, under Section 15 Sub B, Sub C and D, A intends to do anything to or in respect of B during or after the meeting mentioned in paragraph A Sub 1 to 3 and in any part of the world, which if done will involve the commission by A of a relevant offence, and B is under 16 and A does not reasonably believe that B is 16 or over. Section 15 of the Sexual Offences Act 2003 prohibits sexual communication with a child under Section 15A Sub 1, Para A, and Para B and Para C. A person aged 18 or over A commits an offence if, for the purpose of obtaining sexual gratification, A intentionally communicates with another person B, the communication is sexual or is intended to encourage B to make a communication that is sexual, and B is under 16 and A does not reasonably believe that B is 16 or over. Also under Section 15A Sub 2 Para A and Para B, for the purposes of this section, a communication is sexual if any part of it relates to sexual activity, or a reasonable person would, in all circumstances but regardless of any person's purpose, consider any part of the communication to be sexual. In paragraph A, sexual activity means an activity that a reasonable person would, in all circumstances but regardless of any person's purposes, consider to be sexual. Lastly, under Section 15, Sub 4, Para A and Para B, a person is liable of an offence under this section on summary conviction to imprisonment for a term not exceeding 6 months or a fine not exceeding the statutory maximum or both. On conviction on indictment, to imprisonment for a term not exceeding 10 years. The law in the UK punishes offenders only with a jail term. However, this could be said to be ineffective to deter predators from acting out on their provisions. According to National Society for the Prevention of Cruelty to Children, the number of child grooming cases has increased throughout a few years from 3,217 cases to 5,441 cases. Therefore, the UK government realised the severity of this issue. And the following facts are from a policy paper published by the UK Home Office titled Tackling Child Sexual Abuse Strategy 2021. They have invested £20.76 million to build the workforce and technical capacity of the National Crime Agency to improve the National Crime Agency's ability to tackle perpetrators seeking to offend against children via the dark web. They also invested into a system that identifies offenders online, and this system is known as the Child Abuse Image Database, which has facial matching capabilities to capture predators. However, the main objective of the UK government is to prevent child sexual abuses from occurring and prevent offenders from reoffending, where the Lucy Faithfull Foundation helps and advises those with abnormal sexual urges. The prevention of reoffending is dealt by Her Majesty's Prison and Probation Service, where it would provide rehabilitative intervention for those in custody for sexual offences, which includes sexual grooming. Further, the UK has a sex offender registration system, known as the Violent and Sex Offender Register. As a registered sex offender in the UK, their online activity is monitored by relevant authorities and law enforcement agencies can apply to courts for civil orders such as sexual harm prevention orders, sexual risk orders which restricts internet use, interaction with children, or access to certain professions.
Hi, my name is Ming Nang, and I will be comparing Malaysia law and the UK legislation. As mentioned before, the UK punished child groomers with a prison sentence and the fine, whereas Malaysia punished child groomers with a prison sentence but also accompanied with whipping. Also, a child is considered to be under 18. Malaysia, whereas in the UK, a child is considered to be under 16. The main difference between these two countries' legislation is that in Malaysia, for example, under Part 3 Section 11.1 states that where a person who is sexually communicating with a child under Section 11.1 states that subjected to subsection 3, where any person who under Section 11.1a sexually communicates with a child or under Section 11.1b encourages a child to sexually communicate by any means, commits an offense and shall, on conviction, be punished by any means, commits an offense and shall, on conviction, be punished with imprisonment for a term not exceeding 3 years. In Malaysia, it requires a positive act where the accused had actually acted on the offense in order to be charged. Whereas, for example, in the UK law, under Section 15b, c and d, where A intends to do anything to or in respect of B, during or after the meeting mentioned in paragraph A1 to 3, and in any part of the word, which if done will involve the commission by A of the relevant offense and B is under 16, and A does not reasonably believe that B is 16 or over. This illustrates that in the UK, a present intention is already sufficient to charge the perpetrator for the offense of child grooming.
My name is Luwomba Luampa, and I will be discussing the relevant provisions in Singapore in relation to child grooming offences and comparing the law between Malaysia and Singapore that deals with such offences. Firstly, the offence of child grooming will be prohibited under Section 376E of the Penal Code, which states that any person of or above the age of 21 years shall be guilty of an offence if having met or communicated with another person on one or more previous occasions where under subsection A, where the perpetrator intentionally meets the victim or travels with the intention of meeting the victim, and under subsection B, at the time of the acts referred to in paragraph 1, the perpetrator intends to do anything to or in respect of the victim during or after the meeting, which if done will involve the commission by the perpetrator of a relevant offence where in paragraph 2 the victim is under 16 years of age, and paragraph 3 the perpetrator does not reasonably believe that the victim is of or above the age of 16 years. The difference between Malaysian law and Singaporean law on child grooming is that in order to be found guilty in Singapore, the perpetrator has to have met with the victim on one previous occasion, whereas Malaysia does not. The second difference is that in Malaysia, the victim has to be under the age of 18 years for the perpetrator to be charged for child grooming, whereas in Singapore, the victim has to be under the age of 16 years. However, based on the Criminal Law Reform Bill of 2019, which amended both sections 375 and 376, more protection has been given to minors under the age of 16 and those between 16 and 18. One key feature is the removal of the word consent in section 376, which means a person can be found guilty of the offense regardless of whether the minor, 14 years of age or below, has given consent or not, as they are regarded as being unable in the first place to consent. Another feature is the additional section under section 376A, which states exploitative sexual penetration of minor or above 16 but below 18 years of age. This section enhances the penalties given under the old section by increasing the important term to 20 years and fine or caning. The section also ventured into new penalties towards sexual offenses towards minors between ages 16 and 18. In the case of Public Prosecutor versus Lee Xiaoping, where a man had sent explicit messages to a minor while defending himself by saying he was just following the recent trendy words that are used on the internet. The Singapore High Court held that he was guilty regardless, as in the text messages, evidence of him intending to meet up with the minor to perform sexual acts was present. This set out a precedent that although they have never met once, would-be predators would still fall under the offense of child grooming just by making the arrangements with the minor. Also, a person could only be found guilty under section 376E if he is above the age of 21 years, whereas in Malaysia, to be charged under the Sexual Offences Act Against Children 2017, the perpetrator has to be above the age of 18 years.
In conclusion, the Malaysian law on child grooming will be partially satisfactory. It is satisfactory in the sense that there are relevant statutes to ensure that offenders who are arrested are punished. However, it is unsatisfactory due to the nature of the punishment, which in our opinion is not adequate in addressing the problem of child grooming. Furthermore, as mentioned, the UK has implemented their own system in dealing with pedophiles, which we agree is substantially effective in dealing with child groomers and pedophiles. We think that Malaysia should consider implementing the system applied in the UK.